Going. We are absolutely delighted to have Hester Peirce with us today. Hester is a commissioner of the Securities and Exchange Commission. And prior to that, she was the director of the Finance Markets Group at George Mason, at the Mercatus Center at George Mason. So taking time off from that to serve the country and keep financial markets going. Hester said she's going to start with some brief remarks and then take questions and answers. So why don't we just go for it? Hester, welcome.
Thank you, John. It's a delight to be here. Thanks to all of you for being here as well. So I'm just going to go ahead and give a few remarks, and then I hope that we can turn it into a discussion and we can talk about whatever, even things that I don't talk about in my remarks. So I do have to give you my disclaimer, which is that because I am just one commissioner, my views do not necessarily represent those of the SEC or my fellow commissioners. The SEC has a very simple mission: protecting investors, facilitating capital formation, fostering market integrity. And commissioners obviously come to these issues with different points of view, which lead to different emphases and different conclusions about how best to achieve these objectives. I come with a belief in the importance of justifying regulatory intervention. In my ideal world, the baseline should be a presumption of liberty, that people can engage in capital markets activities as long as they don't hurt anyone else in the context of their market transaction. So we can move away from that baseline, but it requires work. We have to show there's a problem, and we have to show that the SEC is the right one to solve that problem, and that SEC regulatory intervention is the best way to solve it without causing worse problems in the process. Of course, Congress moved the baseline somewhat from the liberty presumption, but our mission is still quite constrained. So historically, we've played some basic referee roles in the marketplace. We ensure that public market investors get the disclosures they need to assess the long-term financial value of companies. We regulate financial professionals that serve retail investors. We regulate securities marketplaces and intermediaries. That role has broadened some over time, but right now we're in a phase where it's really being broadened in quite a dramatic way. And so that's under the leadership of Chair Gensler, who's someone I very much enjoy working with. He came to us from MIT, where he was teaching about a number of issues, including crypto. And before that, he had been the chairman of the CFTC. And I think we saw a very active rulemaking agenda when he was chair of the CFTC, and we're seeing something similar going on now, not only in rulemaking, but examination and enforcement. I think our agenda is expanding. And that concerns me. So here are a number of concerns that I have. First, we're reopening rules that we just rewrote under the last chairman, based not on new information, but on the same information. So we had rules, for example, around proxy access. We had rules on whistleblowers that we just completed, and those are being reopened so that we can basically take a different approach than we took just a short while ago. Second, there's a shift in focus away from retail investor protection. One example is the recent proposal to dramatically increase regulation of private fund advisors. So I think about private fund investors as people who are either sophisticated in their own right and able to make decisions for themselves and can frankly afford to lose money. Or there's someone like pension plans or endowments, and these are entities that are represented by very sophisticated, well-paid investment professionals. So we're making a move now to impose a lot more, or provide a lot more protections and spend a lot more of our resources for those private fund investors. If we're going to go down that road, I think we have an obligation to open those up to anyone who wants to invest in them, including retail investors. Now, I would, in my ideal world, do away with the distinction and allow people to opt in or out of the public markets and into the private markets if they wanted, but that's not the world we live in. The agenda also represents a departure from our threefold mission. So increasingly, rulemakings are citing systemic risk objectives as a motivation. We're not a systemic risk regulator. The chair does have a seat on the Financial Stability Oversight Council, which is a systemic risk regulating body, but we ourselves do not have that mission. So, for example, we recently issued proposals around short sales and short sale disclosures, and around, as I mentioned, private fund advisors. Both of those cited, among other rationales, systemic risk. And so my question is, if we collect all this data, what are we planning to do with it? We certainly don't have the expertise to use the data in a way to identify and address systemic risks, and we don't have the authority. Increasingly, rulemakings also have a merit-based tinge to them. So it's not only rulemakings, but it's other activities of the commission. For example, there's been a lot of chatter about why we haven't approved a Bitcoin exchange traded product yet. That, I believe, is a merit-based decision versus based on our rules. The agenda also looks to regulate the substance of what issuers do rather than simply ensuring that they describe what they're doing to their investors. So today, for example, we proposed a rule around public companies' cybersecurity disclosures. Although it's a disclosure-based rule, it's written in a way that very much suggests that we have in mind a particular type of cybersecurity program that public companies put in place. We are very publicly discussing plans for a climate rulemaking, which again, I think would be designed to shift what companies do rather than simply get companies to tell people what they're doing. And then more generally, we are increasingly designing our rules in a way to respond to non-shareholder stakeholders who they've looked at the SEC's disclosure regime and they said, oh, this is a really successful regime. It's a nice way to allow us to name and shame companies into complying with whatever the objectives of these stakeholders are. And so that might be, to take us back a few years, conflict minerals disclosure, or now we're looking at climate disclosures that I think have that same intent. Our agenda is also looking to grab jurisdiction while it's there for the taking. So the current prime example of that is crypto, where the commission is using statements and enforcement actions to deem crypto assets to be securities, which then means we can pull in not only issuers of those securities, but trading platforms and other entities that deal with those assets. So much of the crypto world, I would say, likely will intersect with the traditional financial markets that we do regulate. But it would be my preference if Congress could come in and tell us what they want us to regulate and what they want other agencies to regulate. The agency is also moving very fast. So we're doing lots and lots of rulemaking. We're putting out the rules very quickly, which means that people don't have the time to scrub them for fundamental legal and operational flaws. We're not seriously engaging with commenters because we're not allowing commenters enough time to analyze the rules, write comments to us, and think about how the rules interact with one another. The comment periods that we're affording are shorter than historically we've afforded people. And so I really am concerned that if we have simultaneous implementation, we're going to see some pretty severe problems based just on the operational difficulties of trying to implement multiple rules at the same time. The agenda is also not always evident at first glance. You might look at a rule that looks like it's about one thing, and then it ends up touching on a lot of other things, which can be quite difficult. So that makes it hard for commenters to even figure out what they need to comment on. I'm concerned about the SEC as an institution and what all of this rulemaking and what these other activities will mean for the SEC as an institution. We're being drawn into increasingly political and socially divisive topics, which are better worked out through our political and civil society institutions. Due process, as I mentioned, is suffering because we're treating the public input process as a formality rather than something that really can help us to wrestle with difficult issues. And our staff is being strained as they seek to juggle multiple extremely complex rules in very short timeframes. The continuity, I think, of the SEC is one of the reasons that I really like the 5-member commission structure, which is it allows for more continuity across administrations and over time. But we're now reopening rules that were just completed without any new information to justify the reopening. So that undermines that continuity. And then I think our focus is being diverted from the bread and butter business of facilitating the smooth operation of the capital markets. We're getting into things that take a lot of time and are very difficult for us because they're outside of our natural set of issues that we work on, and they're very contentious issues. And so that means that we can spend less time thinking about the issues that are clearly within our wheelhouse. And I worry even more that the capital markets could suffer. The reason I came to the SEC to be a commissioner is because I believe in the power of the capital markets to support the economy, but also to transform the lives of individuals, whether that's acting as investors or as people who run businesses and draw capital from the capital markets. So what we're doing now appears to me that we're trying to centrally plan capital flows through increasingly granular and politically tinged mandates that place the regulator in the driver's seat and displace the capital markets. And capital markets are such a powerful way of figuring out how to solve the problems of today and tomorrow. And they're much more flexible, better at incorporating the wisdom of everyone in society, and more imaginative than we regulators sitting down today to write rules that are likely to be in effect for the next quarter century. And I worry about retail investors too. As I mentioned, retail investors can't now participate in the private markets. That's where a lot of the activity is happening now. And so as we direct more and more of the capital flows within the public markets to whatever types of companies and whatever types of investments we deem to be acceptable, I think a lot of the profitable opportunities will be outside of the public markets in the private markets, which are not going to be available to retail investors. And so what does that mean for retail investors who are trying to build their retirements? What can be done about this? I mean, I'd love us just to get back to our roots, working collaboratively together on bread and butter issues that matter to Americans. And I think that means that we can, think about fixed income markets, just equity market structure, options markets, the basic things that we all came here to work on instead of trying to think about issues that are well outside our wheelhouse. So I know that's brief, but I'd rather talk about what you all want to talk about. So with that, why don't we go to questions, comments, criticisms, suggestions?
That was absolutely gorgeous. Thank you, and succinct. So let's do questions. If you can raise your hand, and I'll issue a threat. If you don't ask questions, I have a long list of questions ready to go. So you're going to hear from me if you don't step up and do some work. Steve.
You scared me, John. So,
that was the point.
Thanks for that. That was a great great overview. I'd like to hear you. I presume you've made these arguments and expressed these concerns to your fellow commissioners and others in the DC policy community. What is the best case, the best intellectual case for the expansive agenda at the SEC that gives you concern? What do they say on the other side? I'm very sympathetic to your view, so I'd like to get a better understanding of what's driving the more expansionist perspective or approach.
I think what's driving the expansionist perspective is that people are looking at what companies are doing, and they're saying, look, we see externalities, and we need to figure out a way to capture those externalities in disclosure. And so when you say, well, I mean, ultimately, that's not the SEC's place really to regulate externalities. If you're talking about environment, that might be EPA. There are other agencies that are charged with that. But I think the response is, no, from the investor's perspective, it is important to think about those externalities, because at the end of the day, they're going to end up, the company is going to end up paying a price for contributing to climate change, right? And so either it's going to be a reputational price, it's going to be an actual price in terms of the blowback to the company, or it's going to be a price when legislation or regulation is passed to govern that activity. So getting companies to incorporate those kinds of things into their disclosures kind of fits within our mandate comfortably. My response to that would be to say, look, our rules are principles based generally around disclosure. And so the idea is that a company is sitting down and thinking about presenting a picture of itself to its investors the way the managers of the company think about the company. And that means that they're thinking about the risks and opportunities down the road. And so certainly if it's a real estate developer that's building condos right on the coast, and it's going to be thinking about things like, is the sea level going to rise, and is that going to affect the values of our property? So I do think our rules already allow companies and indeed require companies to be thinking about these kinds of risks and opportunities. It's when we adopt these specific rules, I think then we're boxing ourselves in, and we're intending to affect behavior. But I think they also wouldn't necessarily think that affecting behavior is a bad thing. So that's kind of the argument. And I think, look, there are a lot of things that people see are really big societal crises, and there needs to be action from everyone to try to address those crises. I think that's another argument I often hear.
Elena.
Thank you. Yes, the talk was fascinating. And I was wondering whether you could comment a little bit more about the issue of cryptocurrencies and Bitcoins. We all know that with the rise of cryptos and assets currencies, and in general with the increased degree of sophistication of financial markets, one questions whether the SEC has in place the right resources, policies, and regulatory power to effectively ensure what you mentioned is one of its key missions of making sure that markets are fair, orderly, and efficient. Do you think that's the case? And if not, what is missing? And a related question, really motivated by the news of these days, we can see by the hour the increasing confrontational stand of countries like China and the recent invasions of Ukraine by Russia. And so there is a pressing issue related to geopolitical security and stability of being able to financially isolate hostile actors from international financial markets. Do you think such a defensive war, financial war, is possible and feasible? And can the SEC, you think, contribute to this? Thank you.
Well, thanks for those questions. I think on the first one on crypto, everyone in Washington is now trying to get a sense of what crypto actually is all about. And it's not a monolithic asset class. You have Bitcoin, which has been around for much longer, and then you have a whole series of other types of digital assets, crypto assets that have been designed for a whole variety of reasons. So from our perspective, one piece of it is just to deal with the fraudulent activity, which is people taking the crypto label and using it as a way to steal money from other people. And so we've done a lot of that kind of work already, and we have the authority to do that. I think the more complicated questions are around how do we integrate crypto into our financial system, and that's not only around questions of can an exchange traded product be built using Bitcoin spot as the base, which sort of marries the two the Bitcoin world and the very traditional financial world together. So we're dealing with those kinds of things, but then the much more difficult kinds of questions around what does it look like to regulate decentralized finance, where you don't have intermediaries in the way that you do in traditional finance. And so what does that mean for our rules? How do they even apply? So I think there's some real challenges for us to think about there. And then there are questions, of course, around whether it's us who should be regulating or should it be the banking regulators. The state regulators have been very active in regulating in this area too. And so trying to figure out those jurisdictional lines as at the same time as the industry is expanding, growing, and changing very, very rapidly, it's a really difficult thing for us to do. And so I think we're going to see 2022 being a year when both Congress and regulators are pretty active and trying to carve out a path where they can have some role in regulating this space, some more active role. On your second question, I mean, some of that is certainly above my pay grade. Questions around how we engage, use the financial system to engage in foreign policy. But I think one area where we've been introduced to this recently is Congress passed a law that said essentially we had to finally confront the fact that certain countries are not allowing our audit regulator to go in and look at audit work papers and determine whether the audits of the financial statements of companies in those jurisdictions are ones that investors can rely on. And so we're in the process now of trying to address that issue, extricate from our markets companies that have financial statements that can't be relied on. And I think that approach is a good one in the sense that if you want to come to our markets, you have to play by the same rules that other people and other issuers in our markets play by. And so that'll be an interesting, I think, test case for how that works operationally and what the consequences are of us taking that kind of a line in the sand approach.
Thank you. The fight against opacity itself is a step towards greater security in a way. Thank you.
Terry, please. Let me guess.
Thanks, John. I have two questions related to climate change. The first asking really, when you talked about collecting information on systemic risk, how does that incorporate risk associated with climate change? You use the example of a builder looking at building a apartment complex on the beach and understanding that the sea level might be rising. Does your collection of information on systemic risk include climate change kinds of risk? And then a second one related to climate change is, what sort of climate change rulemaking are you thinking about, and how will those affect the extent to which people adapt because they take into account risks associated with climate change?
I'm glad you brought up the link between climate change and systemic risk, because that is another pretty frequent justification for financial regulators playing a role in regulating around climate change, and so certainly for banking regulators, there's one set of issues, but for us as well, I think we, not meaning me, but I think that the commission will try to point to the fact that that's one of the reasons it's good to have more of this information available. Now, what the SEC would do with that kind of information, again, I don't know, and I think it's dangerous for us to try to collect information and give people the sense that we're going to collect it and figure out how to stop systemic risk or even to identify it, let alone stop it. In terms of what we're planning to do, that the climate rule is, Chair Gensler's been talking a lot about the fact that a climate rule is coming, and so I think you can expect to see one relatively soon. And to get a sense of what it might be about, you can probably take a look at a request for comment that one of my colleagues did last April, and the many responses that we got to that request for comment, which talk about a lot of the types of disclosures that people would like to see from public companies. Now, in terms of whether that will change behavior, I think it will change behavior, but I would argue that if climate change poses a risk to issuers now, they should already be thinking about that. And it seems highly improbable that the SEC coming in with a disclosure rulemaking is going to be the one to get companies to think about really pressing issues. Asset managers have been taking a real interest in ESG type issues, including especially, I would say, climate. And so there's a lot of pressure already on public companies to provide lots and lots of information around climate risk. And so some of the thinking around this is probably driven by those asset managers. Now, I would argue that the asset managers have their own they're playing a little bit of a game too, right? Because if they can slap a label on a fund that says they're an ESG fund, they can charge more for managing that fund without necessarily doing much to justify that that extra amount they're charging. In fact, I think what they would like is for us to do the work for them so that they can then charge extra. Now, that may be a little bit unfair, but I think that's some of the loudest voices we're hearing are from asset managers.
If I could just quickly add, I edited a book for a project at Hoover on adaptation to climate change, and a chapter in that book with Matt Kahn really identifies the ways in which private investors have lots of reason to take account of the risk associated with climate change. In fact, if there's a market response to climate change, it's through finance and insurance markets. And the evidence to me suggests they're doing pretty well, probably without the help of government agencies like the SEC.
I think one of the responses you would hear to that is that because there's so many disparate sources of climate information out there, people would argue, well, we want comparable, consistent, accurate information. And if a government regulator comes in and says, well, here's the climate information you have to provide, it will be much easier to compare across different issuers. But I think, to your point, private investors come to it with a diversity of perspectives. And I think that heterogeneity is actually healthy in trying to ferret out what actually matters. And that probably will change over time as well, as science changes, as technology changes. So having a more flexible private sector driven approach, I think, is actually more likely to get to the information that really does matter.
Axel's next, and then John Taylor.
Yeah, John, thank you. And I am an asset manager. And so I would like to just make two comments. We have several regulators. One of them is your wonderful organization. We manage several registered products and a few other items. And we have not launched any ESG product. And we have intentionally stayed away from getting engaged in that game, most notably in part of, I think, what you're referencing. There are a lot of claims out there. And from our perspective and our counsel's perspective, if anything, it creates liability, because a lot of what we see from our peers is not exactly always ESG given from a certain perspective. And so clarity from that point of view from the SEC would probably be most appreciated. So there, the first comment is we're actually not engaging in something that might be worth pursuing because of the uncertainty in the field. The other comment is we consider ourselves a small business, but are regulated like big business. And they are just a general comment that any regulation increases the barrier to entry, has a risk of squeezing out small business. And the margins are being compressed in recent years anyway. And so that's just the challenge with any of these new rules is often that they create a lot of overhead. And we already see boards of various entities that we are on spending a lot of time on things that isn't even in any stage that that is tangible yet. And so we are very much afraid that this is going to significantly impact the small business side of things.
That's a very important point, and I think one we too often don't take into account, which is that regulatory burdens really do serve as a wall of defense for larger entities, whether it's asset managers, and that's actually an area where I worry. I think it's really hard for small investment advisors to compete because the regulatory burdens are so high, or for public companies where every time you add a new requirement, it really does make that burden and that barrier to going from private to public a bigger one. On your first point, I should have mentioned that another area that of focus on the climate side and on the ESG side has been around thinking about advisor regulations. So not only are we looking at public company disclosures, but at how advisors are pitching themselves to investors, and is there a way to beyond what our current rules already require, which is they do require advisors to tell investors how they're managing their money, but is there something more that we need to do to make sure that advisors are not so-called greenwashing or otherwise portraying themselves to be ESG and not doing something that follows through on what they're saying? I think one of the difficulties there is that ESG is such a broad and ever expanding category of things that if we go down that road, it's really fraught for us. Not only then do we have to define what falls within those parameters, but then we have to decide, well, if a fund says it's an environmental fund and it's only investing in natural gas, does that count as environmental? Those kinds of questions are very difficult ones for us to get involved in.
It looks like John, you're up.
Thank you so much, Hester. This is very illuminating. In particular, how you started with liberty and said all these rules are infringing in many respects. And that, as you gave many good examples, and we've heard more since you've spoken. But I wonder if there's a way that this can be combated. In a sense, I hate to say this, but what you need is rules for the SEC rather than rules that the SEC imposes on markets. And that's what I'm thinking. Is there a way that you can make the SEC more resilient across administrations? Some systematic approach or something that would prevent a change in the political aspects to affect the agency. So the question is there a way that you're thinking about establishing rules for the SEC to follow so there's some continuity and you don't have this amazing change you've discussed, and have a little more continuity to the system?
There are some rules already in place. So if you think about, we have requirements around economic analysis built into our statutory framework. And so the idea is you have to be able to identify the problem you're trying to solve and lay out the different solutions and then weigh the costs and benefits and figure out which way to go. And so economic analysis should be informing everything that we do. The problem with that is that it's very hard to actually do economic analysis around a rulemaking, and you're making lots of assumptions. And if you give people only 60 days to respond and you ask them for data, it's really hard for you to get the data in that amount of time. And there are a lot of other limitations on why people might not want to give you data, or if you get data from people, you dismiss it as being anecdotal because it's just the cost that one company expects to face. And I think a lot of times the real consequences of our rules are indirect, and so it can be difficult to figure out how to take those into account. So I still am a big proponent of economic analysis because I think it's just logical for us to be thinking through what problem we're trying to solve. Another thing that would hold us to account on that is if we really did go back and do thorough retroactive review of rules to see after 3 years or 5 years, are they achieving their intended objective? And if not, should we modify them? that's one possibility. But another piece of the governing structure is the Administrative Procedure Act, which is designed to prevent massive flip-flops in policy without a justification for changing. And so that's something that, again, it's a way for people we regulate to hold us to account. People are not shy about suing the SEC. It happens a lot. So that is one disciplinary mechanism. And obviously elections do have consequences, right? So a new chair is going to come in and he's going to have his agenda that he wants to implement. And I get that, but I think it's taken on a whole new meaning when we really do look at the SEC. And as the title of this talk said, we start looking at ourselves as the Securities and Environment Commission or the Securities and Society Commission, where we really are viewing ourselves as the one that can solve every problem that we see out there in society.
I think they call it the whole of government approach. It's official now. Nikki, your turn.
Yes, thanks. So I thought your presentation was very thought-provoking, and one way it was thought-provoking for me was you talked about the expanded role and how it's evolved, and the expansion of the role seems to intensify. And what was going through my mind at the time is the same thing is happening at other agencies of the administration, whether you're talking about EPA or Justice, the Department of Commerce, and some of us on this in this meeting are involved in studying and trying to influence the Federal Reserve. And one of our biggest frustrations is its expanded scope of what it's trying to achieve. So I just wanted to make that comment, but then I have some questions about that. Does it stem from the administration or Congress, or has it become just endemic to the institution? And is there any realistic way to rein in the scope in a way that would, reduce overlap, lead to better economic analysis of the unintended consequences, et cetera, et cetera. But once again, I'm thinking of this from the broader, looking at various agencies, and everyone seems to, their scope seems to be broadening with, and even I can tell you geographically, I know experiences with the EPA where the federal EPA steps on the toes of the local EPA and they fight back and forth with unintended consequences. So I'll just stop there. And where's all this coming? Where's all this going to? And with what implications for, the rules by which we conduct commerce and live?
Well, I mean, on my pessimistic days, I kind of look at what's going on and I say this is hopeless because the public sector keeps expanding and pushing the private sector into smaller and smaller areas of our life and tries to make more and more decisions for us. And I guess on my optimistic days, I think, well, ultimately we'll realize that the decision making by public sector entities is necessarily going to be less effective because it's not as good at capturing the knowledge that's dispersed throughout society, right? You're making decisions based upon what a few regulators in Washington think, informed by the few people that they talk to out there in society, whereas the price system is much more effective at getting information from every last person in society, and that's such a powerful thing. So I'm always hopeful that people will recognize the power of that and say, wait a minute, we need to take a step back and try to pare back our interventions. But I guess that is why I started with the position that I think it's important for us as regulators to think about liberty as we are making decisions, right? As a regulator, I take it very seriously when I'm looking at a rule, because I realize I am taking away the ability of individuals to make decisions that they would otherwise make, and therefore I am cutting off little pieces of information flowing out into the system that would then help the system to function the way it should. And so I think reminding ourselves of the importance of and value of individual decision makers is something that can sort of take us back to the place where we need to be. Now, look, I mean, you brought up the Fed, and when Dodd-Frank was passed, I was really quite concerned because the Fed was given more authority. I felt some of that authority was being taken away from the securities regulators, the capital markets regulators. That makes me uncomfortable too, because I think one of the most powerful parts of the US financial system is that we have such vibrant capital markets. And I think capital markets are better than banking markets at allocating capital appropriately. So I guess I'm not really answering your question, except to say that I think that some of these experiments in taking more decisions and putting them in the hands of various federal agencies will ultimately remind us why we might want to put them back in the hands of private individuals and entities.
Steve, you're up.
Yeah, I want to return to John Taylor's question in response. So, John asked about what kind of rules we could impose on the SEC, and I think other regulatory agencies as well. And part of your response, as I recall, was that, well, I'm going to paraphrase here, we can do cost-benefit analyses, but they're hard to do in a persuasive way. I agree with that, but it seems to me if you can't construct a persuasive cost-benefit analysis in favor of a new regulation, then that suggests the benefits are not big enough to actually, we'd want to implement it given your presumption of liberty, which I share. The difficulty is that the courts don't want to perform the oversight of these analyses by the regulators, and the regulators aren't going to provide a disinterested analysis of their own cost-benefit analyses. So that suggests we might need another party, a third party. It could be an independent part of the government. It could be some kind of independent commission of experts in an area whose sole authority would be to say you did or you did not make a persuasive cost-benefit analysis in favor of a new proposed regulation. I just would like to get your reaction to that as an idea that could be applied to the SEC, could be applied to many other regulatory agencies as well, that would address, I think, at least partly some of these concerns about regulatory overreach and just the proliferation of regulations that that we've experienced in the United States and many other countries around the world for decades.
The SEC has a really interesting history around economic analysis. So long ago, I was a rule writer here at the SEC, and one of my jobs, and I'm a lawyer, one of my jobs was to write the first draft of the economic analysis, which I thought was preposterous. But that was the way that we did it back then. Well, come a few years after that, there was a court case where we got challenged, among other things, based on the economic analysis, and actually we lost. And so that prompted some soul searching at the SEC, and there was a much greater effort made to formalize economic analysis and to integrate the economists into the rulemaking process, and also to expand the number of economists. We've always been a lawyer-driven agency, but now we actually have quite a big group of economists who are doing a lot more around not only rulemakings, but around enforcement actions, helping us think through the economics. So you can see that the courts are willing to look at rules and willing to take a look at the economic analysis. But I agree with you that that's sometimes an area that courts are loath to get involved in. And so one thing I've thought about is, well, we could have the economists at one agency looking at the work of the other to say, wait a minute, you didn't do your job of justifying it. But I also think that those of you economists who are in academia have a role to play too, right? I often look at an economic analysis and think, based upon my undergraduate economics degree, this doesn't seem to really, this rationale doesn't seem to work. But those of you who actually are economists, it would be very helpful for you to take a look at what we're doing. So let me give you a recent example. A lot of the rules that we adopt now, one of the rationales in the economic analysis is we're addressing information asymmetry. That sounds great, right? Who likes information asymmetries? But then my question is, wait a minute, the markets are kind of built around information asymmetries, right? So is it really our role as a regulator to erase every information asymmetry out there? It's one thing if you have a group of insiders at a company, and I know there's economic discussion about this too, but it's one thing to say, wait a minute, the insiders need to provide the information to those outside the company. But it's a different thing when you've got two market participants not associated with the company. If one of them has done the work to get more information than the other, why should that one have to share its information with the other? But that's kind of the rationale we're employing now in some of our rulemakings. And so I'm thinking, why aren't economists commenting on this? Because I think it's really strange. So I think there are other areas too where it would be helpful for outside economists to take a look. I think one of the problems in our area is that there are a lot of financial economists who work on our issues, but they're often looking at very narrow issues, and they're often not really thinking about the policy implications of the work they're doing. And so I don't think we're necessarily getting the kind of advice that we could be getting from outside economists. So I'm going to throw it back on you all.
Maybe we should count comments to the SEC and tenure evaluations. Elena, everyone gets a first shot before we go for second round. So Rick, you're next.
So this is just a follow-on to Steve's comment. I thought historically, with varying degrees of success, OMB had done this regulatory analysis and had required lots of justification and analysis of regulations. Now that's OMB has a political element, but I thought that the regulatory people didn't have quite the same political cycles that other agencies have, and that they would be a natural source.
So I'm glad you brought up the work of OIRA, the office at OMB that looks at economic analysis. One of the interesting features of the SEC is that we are an independent regulatory agency, which means that we don't fall under the direct authority, I guess you'd say, of OIRA. Now, there's debate about this, and I'm not going to get into that debate right now, but that's why our rules don't have the same kind of process that some other rules do. Now, some people would like our rules to run through that OIRA process. But it is, that has been a very effective office at OMB over the years, and has certainly put out guidance around what an economic analysis should look like. And that's guidance that we certainly look at and take into account in the way that we do our economic analysis here.
Andy, you're next.
Yes, thank you, Hester. That was a great presentation. So I have, I think I share some of your skepticism about what can be done with respect to climate. As I understand it from the website at the SEC, there's this goal of a comprehensive framework that produces consistent, comparable, and reliable climate-related disclosures, which sounds extremely ambitious. And so I have a simple question. If the SEC is going to pursue this, what sort of more pressing issues might be put on the back burner that have to do with competitiveness and what you have suggested relate to liberty in security markets?
Well, I think there are a lot of things that potentially get put on the back burner, and I think that is the right way to look at it. What's the opportunity cost of us spending all this time around climate? So I would say one area that I'm concerned about is capital formation at the smaller end of the spectrum. So how are the smallest businesses raising capital? And there are some rules that we could be working on there that I think would make common sense changes that would allow those smaller companies to take advantage of our capital markets. And then, another area that is of constant interest at the SEC is market structure. We spend a lot of time thinking about equity market structure, and I have a lot of concerns about the approach we've taken there, which is a very it's a micromanaging approach, and it's really difficult to figure out. There are definitely some problems in equity market structure. But there are some things that are working quite well. Retail investors have never had it better in terms of how easy and cheap it is for them to transact. So I'm hesitant to make a lot of changes there, but certainly an area we can think about. Fixed income markets are ones that are probably more in need of our attention. We've spent less time thinking about them, and I would like us to think about them. There's some issues like our rules around transfer agents are really outdated. And then I would like us to spend more time thinking about how we can be more accommodating to people who are trying to innovate in the financial markets. So that may be crypto, that's one area, but I think there are other types of innovation that just take a very long time to get the attention they need to get the types of exemptions they would need to be able to operate, which means that a lot of people who have thought about innovating have just avoided the financial markets because it's too hard to do it in our markets. So I'd like us to think about how we could be more flexible and adapt more quickly. So those are some of the areas I would love us also to re-look at how we can allow retail investors to get access to private markets, whether that's directly or whether that's through collective investment vehicles, which is probably the way that more of them would want to interact with the private markets.
I want to take a turn before we go on to second rounds, if you guys don't mind. And I got 10 questions, but I can only get one. So let me ask, you touched briefly on this problem of shareholder governance. You said, in some sense, the stakeholder issue, but also, the mutual funds and asset managers are now voting on behalf of their shareholders. So that, for example, my money's in Vanguard. Vanguard votes for all sorts of climate stuff that I think is totally nuts, but my shares get voted that way. That seems like a sort of a major problem in current corporate governance. Of a small number of people, if you get a hold of the shareholder voting advisory services, then your opinions get voted on my shares. Do you have any thoughts on how to fix that?
So that is definitely a problem, and I think we're exacerbating it rather than fixing it because we're trying to put more and more pressure on large asset managers, large and small asset managers to put a lot of emphasis on voting. And so even if it's if you're thinking of a passively managed fund, should that fund be voting in a way that's active? I could make the argument that that doesn't make a lot of sense, but we're now putting more and more of a spotlight on how the voting happens. And so these external stakeholder groups are looking at asset managers and they're saying, well, we want you to vote in a particular way. I think we need to take a step back, which we did try to do under the last chairman, and say, okay, what is the fiduciary duty? What does that actually mean? And what are the implications? And a mutual fund owns, for example, is the client, right? It's the client to the investor. And so an asset manager should not necessarily be voting all of the mutual funds it manages the same way. If it's a passive fund, maybe they're not voting at all or just voting with management. If it's an environmental fund, maybe they are taking an active role in certain environmental votes, right? But the asset manager taking those votes and treating them as if they belong to the asset manager to be voted in a way that suits the asset manager is not consistent with fiduciary duty. So I think emphasizing that.
I had thought about much more non-voting shares as an answer to this. I would rather Vanguard bought non-voting shares at a lower price in my name. Is that going anywhere, or is that a silly idea? And then Elena gets to go next.
I mean, I think that's not an idea that's gotten a lot of discussion. But again, I think there are a lot of investors who probably feel the same way you do. So I think we are I'm looking around for solutions. Unfortunately, I think right now the SEC is looking to sort of put a thumb on the scale in favor of having all the votes go in one way.
Elena, please, you're next.
Thank you. You were talking, Hester, about and touched upon the issue of capital formation. Now, can the SEC support it? And you mentioned what's on your mind on your more pessimistic days. So I thought I'd share what's on some of economists' mind in their own pessimistic days, which is the so-called issue of the decreased dynamism of the US economy, the well-documented fact that over the past, since the 80s, I should say, few firms are being created, and especially around Silicon Valley here, we all have a sense that fewer firms being created has an impact on productivity, innovation, output, and ultimately growth. So my question is whether you share in the pessimism, you think the SEC is doing what it can, or different policies could be put in place to support capital formations and birth and growth of young, innovative firms. Thank you.
Well, I think we could be doing a lot to encourage that dynamism. I mean, I talk to a lot to founders of small companies, and they're ready to go, right? They just need to figure out a way to get access to capital. And as I mentioned, there's a lot of capital in the private markets now, but it is pretty hard to match it with the people who have the good ideas. And so that's why I think spending more time thinking around that smaller end of the company spectrum on how to get capital to those companies is really the way to go, and encouraging more people to think about the capital markets as a way to release their talents. So I think part of our job is doing a better job of marketing what the capital markets can do. Now that's going to be a complete failure if then everyone who comes into the capital markets is faced with a whole pile of rules that make it so expensive that they want to go running. So I think it's getting the balance right. But we have the people who have the ideas and want to get to work on them. We just make it really hard for them to get matched with the people who have the money.
I guess if I may follow up, one issue that I hear often debated on the other side of the ocean is that regulatory agencies have really usually a trained eye towards bigger entities, how to facilitate their access, how to monitor potential abuse, rather than having regulatory levers in place to help, let's say, the life cycle of new or non-existing entities to get to market and become the firms that we all benefit from. So you don't think that in the space of policy instruments, the SEC is short of necessary levers? It's just a matter of implementing what you have.
Yeah, I think it's just implementing what we have and getting over our bias against smaller companies. I mean, I think when we regulate, we have this image of these very large companies that have hundreds of lawyers sitting in a back room reading all of our rules, when the reality is a lot messier and people can't afford that many lawyers. And so we need to shift our focus and realize that you can't have one size fits all rules. You have to be willing to accommodate some of that dynamism, which can be a little messier at the beginning of the life cycle of a company.
John, go ahead.
One of the questions which is hinted around here is there's so many different levels of government that are involved. In fact, I see Pete Wilson on the phone, who's the mayor of San Diego, governor of California, U.S. senator. He's had all of it. Maybe not the international side, but I can see him there and thinking about this. But could you say a little bit what is the role of the states? We have a federal system, but you didn't mention about that. Is it best to ignore them and stick with the SEC? What's your feeling about that way to get at a little more liberty?
Well, the state regulators play a huge role in the securities markets, and they're they're playing an important regulatory role alongside the SECs. There sometimes are conflicts. There's sometimes where I'm arguing that we should preempt the state regulators because having a uniform approach across the country makes a lot of sense when people are raising money, because they can't. It's very hard for them to raise money only within one state. So I think it's a complicated area. I mean, a lot of people come to the United States and they look at all the financial regulators and they say this is terrible. On the other hand, it's nice to have a little regulatory competition so we can see maybe how one state does it better than others. We look in the crypto space, for example, and there's a lot of innovation happening at the state level, different states trying different things. And even we're able to learn from what some other jurisdictions are doing, some other international. We look internationally and we see what some smaller jurisdictions are doing because they're more nimble, they're more able to come up with a regulatory structure that works for now instead of 100 years ago. So I think we can learn a lot, but it is very difficult for people to navigate the existing financial regulatory structure.
Charlie.
Yes, very interesting conversation. I'll preface my comment and my question is maybe a little too specialized for this audience, but I just retired from 6 years as a governor of FINRA. And of course, FINRA has lots of interactions and reports in some ways to the SEC, is responsible. They are regulated by the SEC in some ways. And yet, in my time there, I found that in some cases, we were frustrated in seeking ways to become more efficient, to specialize supervision and other aspects of what FINRA's responsibilities were with brokers and dealers. I found the SEC in some ways, like you said, at times stuck in very old ways of thinking about the best ways to supervise in terms of getting efficient at it, or as FINRA was trying to specialize its supervision resources on risky firms. So I'd love to hear just your kind of thoughts on that relationship between FINRA and the SEC, and how you think that, I guess I would call it, delegation of supervision is working out, and whether there are things that the SEC might learn from some of the what I think of and some of the more innovative things that FINRA has tried to do at times.
Well, I should have mentioned FINRA before now. I think that's another unusual aspect of the way the securities markets are regulated. We have FINRA, which is a self-regulator. It calls itself a self-regulator. I would call it a quasi-governmental regulator, but it essentially adds another layer for broker-dealers. And I think we do have something to learn from the way FINRA is trying to adjust and modernize its inspections program, for example. But the relationship is not always an easy one, because people end up having to go through 2 layers of review. You've got to get stuff through FINRA, and then FINRA has to kind of get the guidance from us in terms of whether we're okay with the approach they're taking. It can be quite difficult, and so I think FINRA now is under leadership that has really tried to take a really holistic view and see where change needs to happen, and that's important. We could probably learn a little bit from that approach, and I think we could coordinate better. There have been a lot of efforts for our examiners, for example, to coordinate better with FINRA examiners. So there's certainly still work to do, but I think we rely heavily on the functions that FINRA plays, and so I'll keep looking at that relationship and seeing what we can do to make us work better together.
I have a couple of questions, and I'll ask them one at a time until someone raises their hand and tells me to stop. So first, I'd like to go back to the climate question and pose it a little less politely than other people have posed it. And part of this is the ESG thing too. If you read IPCC reports and take the actual science even vaguely seriously, remember, climate is the probability distribution of the weather. So climate risk is an unexpected change in the probability distribution of the weather that has a bad effect. Now, for systemic risk, it has to blow through equity before it gets to debt. I guess you worry about equity disclosures as well. But the frank answer, there is no such thing as climate risk, at least over the next 5 to 10 years that we can even think about risks to profits. There is such a thing we just found out as nuclear war risk or pandemic risk, but the risk to climate as the fraction of variance in any firm's profit is zero if you take it at all honestly for what it means. So how are we going to disclose a totally fictitious risk? I mean, I understand the point is we want to implement climate policy, which is to stop investment in fossil fuels before alternatives are available. And the legislatures won't do it, so the whole government's going to strangle them off financially. We're going to put financial sanctions on oil and gas, which is pretty much what we've done already. It's very hard to borrow money to drill a new well anywhere. So here's the conundrum for your boss, I guess. How do you disclose a risk that doesn't exist? I was actually almost for this because if you actually have a legal disclosure that you can get sued at, you can't make stuff up. You can't say, well, it could, maybe, might have, who knows what'll happen. But on the other hand, if you start, maybe the disclosure will have to be, who knows, maybe kind of whatever will happen. And that just writing down investing in anything related to oil or gas exposes you to such legal risk that shuts it down. So anyway, how are we going to square this circle of disclosing completely fictitious risks? And is that going to clean things up by you can't greenwash? Or is it just going to be open season to sue people and therefore strangle these industries? And note those industries have sort of a right to access to the financial system.
It's a very difficult area to regulate in because it is so different from some of the other areas we regulate in terms of how certain you can be about the disclosures that you're making and what kinds of assumptions you're making to go into those disclosures. So I think people who are calling on us to do climate disclosures are saying, look, there are a few things that companies need to be thinking about. They need to be thinking about physical risk, which while you say, okay, you can't predict that kind of thing, I think they would say, well, you can, physical risk includes severe weather, so hurricanes.
And we do that now.
Right. So that's one.
That's not new. Yeah, we have a plant located where it might get flooded. Yeah,
exactly. Right. So they want more, I think, more specific disclosure around the physical vulnerabilities. And then the second.
Tiny. Anyway, go ahead.
The second piece, I think, is the transition risk one, which they're saying, look, we can see the writing on the wall, which is that all these governments are saying that oil and gas are doomed, and the future is in wind and solar, and so you have to take that into account when you're thinking about your business. And so, to some extent, it becomes a self-fulfilling prophecy, right? If you can say, no, I can see the regulation coming down the line that's going to prevent you from doing that, so you have to start abiding by those regulations now, then you don't ever have to actually adopt the regulations.
We don't require political risk. Oh, some congressman might pass a law that shuts you out of business. You have to disclose that. Nice business you got there. Something might happen to it. So if you were to say, let's have a rule, disclose all possible political risks of crazy things that Congress might do to shut down your business. Sure, fine. But that doesn't seem to be applied.
Well, but I mean, I would argue that our existing principles-based disclosure rules, if you really had a credible threat that, say you're an alcohol business before Prohibition, and there's a credible threat that Prohibition is going to get passed, then yeah, you probably should be telling your investors there's a good chance that we're going to be shut down in 2 years because this legislation looks like it's going to pass. So it's not as if the climate transition risk is a new idea, but I guess my concern is that the focus on it is it's a different level of emphasis than we've applied in other similar situations in the past. And I think that I worry not only about how reliable the climate disclosures themselves will be, but what the effects will be on our other disclosures. Because I think when you start watering down one part of your disclosure system, it has adverse effects elsewhere. When you start telling us that disclosures made based on essentially guessing are accurate and comparable and consistent, then what does that mean for what companies are doing in other areas of their disclosure? That's really of grave concern to me.
Once you start pleasing the regulator on one disclosure, you start pleasing the regulator on. Let me ask you a quick nerdy question, then I'll give Terry a turn. Your bread and butter, regular markets, seem to be under some, there's a lot of strange volatility. At least last time I was following this a while ago, the high frequency traders were not obviously doing a great job. There was the flash crash business. My colleague Eric Budish, you probably have seen his work, pointed out that there's an SEC rule, actually, I think it's an SEC rule that's causing some of the trouble. First come, first serve, which gives you a race for speed. He was proposing periodic, every second batch auctions instead. We saw the Treasury market go nuts and the Fed jump in. Actually, markets proved to be very unresilient in the pandemic. The Fed jumped in and decided to put a floor on everything. Well, maybe now there's an extra reason why nobody keeps any cash around to intermediate. There doesn't seem to be much risk capital willing to take the other sides of things. Is this a set of issues on your mind?
Well, I think certainly the Treasury markets are on everyone's minds. I mean, those markets should be the most liquid and the ones that operate, most seamlessly. So I think that's something that we look at, something that Treasury looks at as well. In terms of high frequency traders and generally equity market structure, there is a real temptation, I think, for me as a regulator to come in and say, let me start pulling out rules I don't like. There's a particular rule I don't like. It's the order protection rule. It's basically a rule that forces you to look around the markets and send your order to the one where the best price is. It's a little more complicated than that, but it's led to a lot of fragmentation in our markets. It's led to some strange results, and I think it's us trying to micromanage how orders are processed. So I've heard there are people who are calling for this auction type approach, which is certainly one that I think might work quite well for some securities, but I worry about us coming in as regulators and substituting one version of micromanagement for another, saying, well, this one lines up better with the economics. Why not, to the extent possible, open it up so that there can be experimentation and that different marketplaces can try different things? And that seems like a better approach. But right now we have so many constraints that everyone is basically forced into the same mold. So yeah. I'd like to see us just allowing more experimentation.
Freedom. Terry, let Emily have the next chat because she hasn't had a chance yet. So Emily, go for it.
Hi all. I know we've talked some about crypto, but I was wondering if maybe I could, hopefully I'm not the last question, but bring us to a question that may be a little different for some in this group. But can you tell us anything about how you're thinking about NFTs and NFT fractionalization and anything that you think we're likely to see in the next 6 months to a year on that?
Well, you're definitely asking a question that I get asked a lot. So NFTs are non-fungible tokens for those of you who aren't crypto people, and they've really taken off in the last year or so. They're a way for people to try to monetize their art and their music, and people are thinking about ways to use them as a substitute for tickets to events, and there are all kinds of really interesting uses for NFTs. They kind of allow the real world and the digital world to meet in an interesting way. So you're drawing in a lot of non-crypto people into the crypto world through these NFTs. So what I've said in the past is that NFTs are a broad category of things, and they're being used in many different ways, including, you mentioned fractionalization. People are using them. There's financialization of NFTs. People are lending based on NFTs. And so, of course, when those kinds of things happen, you have to think about how the securities rules and other financial regulations might affect them. Now, I would like us as an agency to put out some guidance and some lines where people can think, maybe these are areas where I need to be particularly careful in designing these things. Some of them come with governance rights or revenue streams. Again, all areas where people should be thinking about how potential interactions with financial regulation. But so far, I haven't been able to convince my colleagues to put out guidance. I hope that this is not an area where we end up putting out guidance through enforcement, as we have in so many other areas of crypto. But I don't have any predictions. I think you got to ask the chairman for predictions on what's going to happen in the next year on NFTs.
Well, with that, I'm sorry, Terry, we've run out of time. Hester, this was just wonderful. Thanks for your great presentation. Thanks everyone for hard questions. Let's give Hester a virtual applause.
Thank you all
Thanks
so much. This was a lot of fun. I appreciate your time.